Hello everyone and welcome to the webcast. My name is Christine Dursey Davis. I'm the Executive Director of the Ohio chapter of APA and Vice Chair of the New Urbanism Division, and I will be the moderator for today's webcast. Today, Friday, March 13th, we will hear the presentation responding to the FCC new collocation rules, how to avoid deemed granted. For technical help during today's webcast, type your questions in the chat box found in the webcast toolbar to the right of your screen or call the 1-800 number shown. For content questions related to the presentation, type those in the questions box, also located in the webinar toolbar to the right of your screen. And we will answer those at the end of the presentation during the Q&A. On your screen is a list of the sponsoring chapters and divisions. Thanks to all of the participating sponsors for making these webcasts possible and free to members. Today's webcast is sponsored by the Northern New England chapter. To learn more about APA's chapters, visit planning.org/chapters, and to learn about APA divisions, planning.org/divisions. On your screen is a list of upcoming webcasts. To register for these webcasts, visit utah-apa.org/webcasts. And to log your CM credits for attending today's webcast, visit planning.org/CM. Or you can go to your dashboard and select today's date and today's webcast. And this webcast is available for 1.5 CM law credits for live viewing only. Some recorded webcasts are available for distance education credit, and for availability of those, again, check the webcast webpage at utah-apa.org/webcasts. And like us on Facebook, Planning Webcast Series, to receive up-to-date information on our upcoming sessions. We are recording today's webcast, and it will be available on our YouTube channel. Just search Planning Webcast on YouTube or visit youtube.com/planningwebcast. We'll also have a PDF of today's presentation, and it will be available at ohioplanning.org/planning webcast. Okay, I'd now like to introduce today's speaker so we can get rolling. Gerard Lederer is today's speaker, and he is a partner in Best & Krieger LLP's Municipal Law Practice Group in the firm's Washington, D.C. office. Prior to joining the firm in 2011, he was an attorney with Miller & Van Eaton, a nationally recognized telecommunications law firm. Mr. Lederer serves as legislative counsel to Telecommunity, a collection of local governments dedicated to ensuring respect for local rights in federal legislative activity. Lederer is a well-known advocate for public and private property owners regarding issues of law and policy arising from federal and state communications legislation and regulation. He is also one of the nation's leading experts on marketplace solutions for the integration of technology into commercial real estate. Mr. Lederer is the author of Critical Connections and Wired for Profit, two leading guides on the integration of telecommunications technology into office buildings. He developed the first model license agreements for access to buildings and rooftops to help telecommunications service providers and property owners protect their interests. Mr. Lederer has served as Executive Director of Advocacy and Research Advancement for the Building Owners and Managers Association International, BOMA, Executive Director of Government Affairs for the United States Telephone Association, and General Counsel of the United States Conference of Mayors and Chief Deputy City Commissioner of the City of Philadelphia. He is a member of the Federal Communications Bar Association. Mr. Lederer is admitted to practice in the state of New Jersey and the District of Columbia, and is an inactive member of the Bar of the Commonwealth of Pennsylvania. He received his law degree with honors from Temple University School of Law and his undergraduate degree, also with honors, from Haverford College. With that, I'm going to turn it over to Mr. Gerard Lederer.
Thank you very much, Christine. I was doing fine till you mentioned that this is recorded, and so now I will be scared to death as we move forward in the whole process. Good afternoon, everyone. Thank you, Christine. It's nice to have a little feedback. I want to thank Christine for everything she does to put these together, and I'd like to thank Ben Frost for the invitation to do this program. Again, I'm Jerry Lederer with Best in Krieger, and I apologize. I did not realize that our marketing folks had sent the biography that goes on for 2 hours. We'll do it shorter next time. I apologize. We, believe it or not, law firms have got general counsels that we have to listen to as well, and this is a requirement from ours. So I'm about to give you everything that I know and to give you my best insights that I possibly can, but this doesn't create an attorney-client relationship. I also want to take this slide to thank Tripp May. Tripp is an attorney in the telecom group, a different law firm who's a dear friend, and he and I did a presentation a couple weeks ago for Nutella, and with Tripp's permission, I stole some of his slides and stole some of his photos. And so if you see any photos or slides that don't have typos, you know they're Tripp's. If you find anything with a typo, it's more than likely mine. Before we start, I did want to just offer you a quickie addition. Between the time that these FCC rules came out and today, something else happened at the Supreme Court that's important for planners and city attorneys alike, and that is the Supreme Court addressed a case called T-Mobile versus the city of Roswell, and that had to do with not 6409 but section 332C7, and it spoke to the issue of an in-writing requirement. Folks know that you can deny a cell site, but you have to have a couple things that you need to do to protect yourself. So you can't unreasonably discriminate. The prohibition can effectively prohibit the provision of services. You have to act within a reasonable period of time, and the decision to deny has to be in writing, supported by substantial evidence. And historically, the question has been, does that mean you can do it in 2 different documents? For instance, can the Planning Commission write up all the reasons why it shouldn't be approved, and that's the documentation of substantial evidence, and then have the City Council deny and reference that report? And what the Supreme Court said is, yeah, you can do that. The denial and the substantial evidence need not be in the same document, but they created a new test, and this is so very important. Both of those documents must be essentially contemporaneous. And so the secret is, keep an eye on your shot clock. But if your report from the Planning Commission or your licensing board or whoever or your zoning board is not going to be ready in time for the actual denial, then postpone the denial if you've got the time vis-a-vis a shot clock, because if they're not essentially contemporaneous, you may not be in compliance with the obligation that the decision to deny must be in writing and supported by substantial evidence. So again, I just wanted to add that one extra point. This is a new change in the law that's happened since we all last talked. Let me talk to you about what the goals of today's program are. I'm going to fly through what the rule says. I want you to take away that there are now 3 federal shot clocks for citing wireless devices, and that all 3 of these shot clocks apply to DAS and small cell applications. I know that that's the question that we always get. The reason I'm going to fly through it is that BB&K and the American Planning Association have an hour-and-a-half long program that details everything that's in the order, and you can find that on YouTube, either at the APA site or at the BB&K site. It was from November the 5th. If you don't want it, that one, as I mentioned, Trip May and I did a program a couple months ago for NATEWA, the National Association of Telecommunications Officers and Advisors. It's up on their webpage. And then finally, for folks that might be listening in that are IMLA members, IMLA ran a program I guess it was in December, that was run by, or was the presentations were by John Pessel and Jonathan Kramer. Both of those gentlemen are dear friends of mine. They're terrific lawyers, and they did a really, really nice job. So if at the end of this you go, ooh, I've got lots of questions that weren't answered and I'd like to know more about it, know that there are other sources out there. Please go for it. So I want you to know that there are 3 different shot clocks, and we'll talk about it. We'll talk about the law enough so that you can determine whether or not your laws, your forms, your practices are consistent with this new FCC rule and these new time frames. I would suggest that they're not. And if they are not, then we go through a decision tree at the end of this presentation that asks you, what is it that you want to do? Do you want to change your laws to conform to the new rules, or do you merely want to change your practices? Because one of the nice things is that, when the city attorney gives you a lot of these ordinances and proclamations that you want to do, they always add on a lot of this boilerplate at the end, and part of that boilerplate is typically says that any part of this law that's inconsistent with federal law, is not enforceable. So, and a lot of times just because they change the rules at the federal level doesn't mean that you have to rush right out and rewrite your laws. And so I do think that there's an obligation for you to change your practices, and that starts on April the 8th. I'm not sure that there's an obligation that you have to go in and actually rewrite your laws, but we'll give you some ideas on maybe how you can do that and do that in a painless way. And then finally, are there things that you can do to affirmatively seek to reduce the impact of this order? And I think that there are, and we'll talk about those, and hopefully when we get into the Q&A, folks on the call will have ideas how you think it might happen as well. So this is sort of the schedule here. This is the report that we're talking about. It was issued, it was adopted on the 17th of October. It was released on the 21st. It was not published in the Federal Register until January 8th, and that's an important date because that's when appeals and reconsiderations run from that date. And it was to be effective 90 days after publication in the Federal Register, and that takes place on April the 9th. Even within that effective date, there are 3 sections that are subject to OMB review. That is, there's a 30-day letter that you have to tell the applicant whether or not their application is complete, a 10-day when you have to tell them whether or not a subsequent application is complete, and then a deemed granted letter that has to be sent to you by the applicant to claim or to document that the time has expired, the 60 days have expired, you didn't make a decision, and therefore it's deemed granted. Those 3 documents are in fact subject right now to OMB review, and we'll have to see where that all shakes out. So here's the rule itself. The rule itself is section 6409A. It's been codified at 47 U.S.C. 1455. I'm not even going to waste your time reading through all this, because what I've tried to do is reduce this basic rule, this longer rule, to a basic rule, and that is state and local governments may not deny and shall approve any eligible facilities request so long as it does not substantially change the physical dimensions of the existing wireless tower or base station. Now again, even shortening that, that's still a mouthful, and you're sitting there saying, man, there are a lot of terms in there, and none of those are defined, and there's certainly none of those were defined in the statute. And what the FCC's order does, report and order does, is it goes through and it defines those. And so that's what we're going to try to do here. We're going to keep coming back and touching base with that basic rule. and then we're going to highlight the next term, and then we're going to explain it. So what is an eligible facilities request? Well, collocations and modifications, including the removal or the replacement of wireless transmission equipment at an existing wireless tower or base station. That's what an eligible facilities request is. And wireless transmission equipment, and this is so vitally important for folks to pick up on, means any equipment that facilitates the transmission for any commission licensed or authorized wireless communication service. So what that means is that traditionally when we've thought of 332, we've thought of cell towers. That is equipment that is associated with cellular telephones. Okay, 6409 is much broader. If it's a wireless service that is done pursuant to a licensed or a recognized unlicensed use, then it falls in the category of wireless transmission equipment. Again, please note that it's much broader than in the past. So again, we've talked about what an eligible facilities request is, and it's very broad. Now, what are we talking about when we're saying an existing wireless tower or base station? Well, a wireless tower is any structure that is built for the sole or primary purpose of supporting any commission licensed or authorized antennas and their associated facilities. Well, let's put that, let's you know, get rid of the words and look at what we mean. So we've got three examples here, right? The left is a palm, or you know, it's a screened tower. That's a tower, right? Because it was put up for the primary purpose of supporting wireless devices. The one in the middle is the classic definition of what a tower is, and again on the far right, it's another camouflaged tower here in the form of a flagpole. Now, what's not here? You know, think about things, right? In your community, what's supporting a lot of these things, right? There are lots of buildings that do that, water towers, etc. Those are not wireless towers. And why aren't they wireless towers? Because of definition, that they were not built for the sole or primary purpose of supporting commission licensed or authorized antennas and their associated facilities. So, oh, it's exciting, it's exciting. Then what the commission did was it came back in and it talked about base stations. And base stations are, and again, let me just go right to my English definition. That's the transmission equipment itself and any non-tower structure that supports transmission equipment under a valid permit for a wireless use. Again, that's important at the end. So let's give you two examples of base stations, right? Both of those pictures contain non-tower structures. That is what I mean by non-tower, things that were not built solely to support wireless, but they are base stations because they support legally permitted wireless transmission equipment. On the left-hand side, if you look at that building, that sort of cupola on the top is a screened wireless housing. On the right-hand side, you've got a typical street lamp, perhaps a bit more historic or low light, so that it's not so bright at night. But you can see that both of these structures that were not created solely or primarily to support wireless structures are now doing that. And the reason that they're a base station is because they are supporting legally permitted wireless transmission equipment. So if someone had put something up on that rooftop that was not legally permitted, that would not render that building into a base station, and therefore would not make that building and the growth at that building permissible, again, because you have to permit, there has to be a permit to convert something that has another use into a base station. So the same thing with your water towers, same thing with rooftops, etc. Absent a legal permit, then it's not a base station. So now we come to the crux, right? Because we've talked about what eligible facilities are. We've talked about what's a wireless tower, what's a base station. They're permitted to have these modifications so long as it does not substantially change the physical dimensions of the tower or the base station. So what does it mean? Well, let's the first thing we need to know is that the Commission created two different standards. There's a standard for inside of the rights-of-way and a standard for outside of the rights-of-way. And then there's a standard for height and there's a standard for width. So let's look at the height standard. If you are outside of the rights-of-way, a tower can grow an additional 10% or 20 feet for an additional antenna array, again, so long as it's not inside of the rights-of-way. If it's inside of the rights-of-way, it can grow the greater of 10% or 10 feet. And so the bottom line is for the minimum growth permitted is 10 feet. So, and this is one of our issues that is on appeal. The record talks about some of these base stations might be as small as a deck of cards. Under these rules, a deck of cards can grow to be 10 feet tall, and we'll learn in a few seconds, 6 feet wide, and I'm sorry, 4 feet wide, and that is not a substantial change. And if all of you are shaking your heads saying that's absolutely crazy, we agree with you 100%. But again, understanding the first question that you have to ask yourself in determining whether or not it's a substantial change is whether or not the tower or the base station is in the rights-of-way or not, because there will be two different standards for that. Okay, then we have to talk about the width. The width can grow outside of the rights-of-way 20 feet or the tower's width at the level that the change is going to take place, whichever is greater. Okay, and again, that's for towers outside of the rights-of-way. For towers inside of the rights-of-way, it's 6 feet wide. So 10 by 6 is the minimum growth that is guaranteed. You can grow as large or as wide as the tower happens to be at that level, but again, no less than 20 feet if you're outside. Anything greater than that would be a substantial change and therefore would not be subject to the fast track of 6409. Another area that's important is that if there is any excavation outside of the leased area, that is a substantial change. And again, I think that's something that gets missed often. Okay? The fourth substantial change is that if the eligible request in any way, shape, or form defeats the existing concealment elements that were outlined in the permit. So again, I think what we're going to see at the end of this presentation is that I hope that folks will start to think about, applying these types of requirements more frequently going forward, because in doing that, you're going to give yourself additional abilities to manage these things in the out years. Let me steal a sip of water real quick. Also, a substantial change occurs when the proposed co-location would violate a prior condition of approval that does not conflict with the Commission standards for a substantial change. And before you ask, let me give you the answer to the question that everyone asks. Well, Jerry, my city has a height limitation on all towers, on all structures. And our height limitation is 100 feet. And this tower is now 100 feet. And they want to go up to 110. Isn't that a prior condition of approval? And the answer is no, because the Commission makes very clear that the height issue is something that would conflict with the Commission standards for a substantial change. Now, again, at the end of this presentation, I'm going to make a suggestion to you all that what you might want to do is you might want to push your height limits down a bit so that you automatically include or anticipate the 10% change as a way of sort of reducing what will happen here. So again, these are some of the takeaway points. Believe it or not, I think the Commission, to their credit, tried to create an objective standard for what constitutes a substantial change. And that objective standard would be based upon the height of the change, the width of the change, the number of cabinets that are added, excavation, camouflage, and compliance with certain prior conditions of approval. Again, if you want to go through those things in detail, go find the November 5th presentation, and we spend a great deal of time on each one of those. The other thing is that it's disjunctive. That is that an applicant must comply with all of these measures. So it's not 3 out of 4, 4 out of 5. If they violate but a single, it's a substantial change, and then they are not eligible for the fast track of 6409, and then they reapply under 332C7. It's not fatal. They just don't get the fast track. They don't get the answer within the 60 days. It's cumulative in that it establishes a cumulative limit for the increases that depend on the structure type and location. Again, one of the issues that was a real concern after the Congress acted was, well, wait a second, if we can go up 10%, can they go up 10% every year? And the commission did clarify, and I'm grateful to them for this. No, they said whatever the height of the facility was on 2/22/12, that's the day that President Obama signed the law, and it was a big law, this was a portion of it, signed that law into effect. That's your baseline, and everything can go up whatever the non-substantial increase is from that baseline. So for instance, if I'm in Philadelphia and somebody put up a tower in 1998, and they went to city council or they went to the license inspection, and they were able to increase the size of that tower from 100 feet to 130 feet, and that tower was 130 feet on 2/22/12, the baseline for the height of that tower and how much more it can grow is not the 100 feet, it's the 130 feet, but then it's done. When it goes beyond, so say it's 13 feet additional, when it goes to 143, it's done being able to use the fast track. If it comes back in 2020 and says we want to go from 143 up to 160, well, the local government may choose to allow them to do it, but it's going to happen under Section 332. It's not going to happen under 6409 because that automatic or guaranteed growth goes away. Again, the other point is that there are lower thresholds in the rights of way. And the way that some of us want to think about this is what the rule does is it sort of effectively creates this invisible envelope around the structure within which the wireless infrastructure can freely be modified, or they can freely modify their transmission equipment. Again, I want to caution people on that. They can't freely modify. They've got to let us know that it's happening, and they have to get our permission. The last point I want to make here is that this only affects local government in your regulatory capacity, not in your proprietary capacity. And so hopefully planners and city attorneys are scouring any wireless lease or license agreements that you have to make sure that you preserve for yourself the right to approve and hopefully get a fee share on any co-locations that take place on government property. Also, if you have greater rights as a landlord than you do as a regulator, it might make sense to have an ordinance that prefers the deployment or the installation of wireless facilities on your property, because then you can regulate, or then you can manage is a better word. You can manage those facilities with your landlord hat more than your regulatory hat, and in so doing, I think you can strengthen where you want to be and how you want to do it. So there's one other rule now. So we talked about what's a substantial change, what's a wireless tower, what's a base station. Here's the sort of the hammer, right? So and that is the commission creates a new 60-day time period. The time period commences when the application is submitted. That's a significant change, right? We've always talked about that the time would begin to run when the application is deemed completed, not on 6409. It is considered the date, the clock begins to run when it is submitted. You can toll the clock, the 60-day clock, by mutual agreement or by sending them in writing an incompleteness notice. I mentioned this before. These are sort of in a little bit of limbo right now because of the OMB review, but under the rules, you have 30 days in which to inform an applicant that their application is deficient. It has to be done in writing, and you have to specifically identify that which is missing. When the applicant, and until they send something back to you, then the clock is tolled. When they send something back to you, the clock starts to tick again. You have 10 days in which to review their subsequent or their supplemental application. And if you find that everything is in there, then that's great. If you find that things are still missing, then you've got another 10 days in which to inform them. But make it very clear that you cannot inform them that something is missing unless you put that on your first list. So take your time and make that first list complete and exhaustive and all-encompassing, because there's not an opportunity for discovery on day 31. Everything is there, and you need to move forward. Disputes will be resolved in the courts, not the commission. Let me just go skip real quick to catch up. Here are some of the takeaway points. Okay. First big point is a huge victory for us. Applications are still required. I mean, an awful lot in the industry felt that they ought to be able to do self-help here and they could just move forward. That's not the case. A permit, an application is still required. You can still require that they file it. There's this new 60-day mini shot clock. Within the 60-day mini shot clock, there are subsequent or smaller shot clocks, 30 and 10 days, and we've just talked about those. Deemed granted is this new remedy that's created for our failure to act. That's one of the issues that we are appealing for a number of communities, and some conditional approvals are okay. Okay. Why don't I skip the Q&A and we'll get to the, if folks want to ask these, we can get to these. Okay. The order doesn't just speak to 6409, but the order also talks about 332C7 terms, and it clarifies how the shot clocks work and the tolling shot clock works for 332C7 as well as 6409. I think the first thing is the shot clocks in 332C7, which are 90 days for co-location or 150 days for new sites, those are not changed. The day that you start to count is changed. Most people viewed 332C7, the clock didn't begin to run until the application was deemed complete. That's not the case anymore. The shot clock starts as soon as you receive an application. And again, you're going to see on an awful lot of the next slides the same little time arrow up there to understand that there are 4 deadlines. Your 30 days for incompleteness, your 60 days for 6409 co-locations, 90 days for 332C7 co-locations, 150 days for new sites. So there's no shortening of the shot clock, but there is I would say that there, in the sense there is a shortening because the clock starts on day 1, not when the application is deemed completed. Unlike 6409, there is no deemed granted relief in 332C7. That's the traditional way people have got to go to court and claim that either we didn't act in a timely manner or we're somehow denying them the deployment of their services. Whatever the arguments may be, they're always still the same. The order does make very clear that the shot clocks apply to DAS and small cell systems. There had been some confusion on this, primarily because a lot of the DAS and small cell folks were coming in and saying that there were Section 253 telecom providers and they weren't trying to do it under 332. Now they're going to come in and they're going to say they're both. So they're going to claim that they need to be treated comparably, if not identically, to other telecom providers in the rights of way, and you're going to have to, address their applications within the time frame, whatever it happens to be. There is no per se violation for preference of municipal property, and moratoria have no impact on the shot clocks. Now, I think a number of us have noticed that the city of Spokane has just imposed a moratoria on new sites, and it'll be interesting to see how that plays out. But the commission on a number of occasions says that moratoria will have no impacts on shot clocks, so we'll see where that all goes. So we've talked about what the rule says. Now, yes, I went through it extraordinarily fast. You're all allowed to be mad at me. Tough luck. I told you where else you could go for the information. What we're going to do is we're going to shift now. We're going to talk about what your responses might be to the order. And the first thing is I think it helps to have a timeline. So we know that the order was issued on January the 8th. That was the trigger date. Reconsideration petitions were due on February the 8th. One was filed, has nothing to do with really local government. The appeal date was due on March the 9th. That's this past Monday. In fact, there were 2 appeals filed that will be consolidated. On March the 6th, Montgomery County, Maryland filed an appeal in the 4th Circuit Court of Appeals. That's the circuit for Maryland and Virginia. It's also considered the rocket docket. It's the fastest moving of all the federal circuit courts. On March the 9th, the following Monday, about 8 different jurisdictions filed in the D.C. Circuit Court of Appeals. Under the way the rules work is that everyone that files at the FCC has a choice. You can file in the Circuit Court of Appeals where you live, or you can file in the D.C. Circuit Court of Appeals because that's where the FCC lives. And so the city of Bellevue, Washington, a collection of Texas communities called TechPhilly, the Texas Coalition for Utility Issues, the city of McAllen, Texas, and then a number of California cities, the city of Los Angeles, the city of Ontario, Redwood City, Burlingame, and I'm missing one, and I apologize. Ontario, the city of Ontario, filed an appeal. Again, they'll be consolidated. Folks have, and this state is wrong, and I apologize. Folks, if you want to intervene as a matter of right, you have until April the 6th to file a notice to intervene. Anyone that's interested, give me a holler. Obviously, sometimes the nicest thing about intervening is that it's a way for your community to help support the underlying appeal, but at a significantly reduced cost. If folks want to do that, you have my email address at the end of this, and please let me know. So that's the legal idea. So now there's sort of the regulatory response and the planner response. And we know that April the 8th or April the 9th is when the order will go into effect. And so then the question is, what is it that you need to be doing, and when do you need to be going about it? And it seems to me that if I'm a planner or I'm a city attorney, I have 2 things that I need to do right now, and that is I need to change out my forms and my time frames, or at least amend my forms and my time frames to be consistent with this new time frame that you see across the top of the screen. And I think I also want to make sure that I go through and I police my lease terms to ensure that co-location requires my approval, and I think I want to do that right now. Next couple slides are really sort of, and I apologize for them being as pedantic as they are, but this was originally written for city attorneys, and they're not as smart as city planners, and so I can hear the howls now. So this is a little bit pedantic, but I don't know how else to do it. So some do's and don'ts. I think the do's, one is that you ought to examine whether or not your laws and your forms are consistent with the new order. As I say, probably not. And so you can clarify in your ordinance or your government practice manual that DAS and small cells are entitled to the shot clock, because that's what it tells us. We also know that the FCC said it's okay if we enact ordinances that prefer government property for cell locations, and again, for all the right reasons. The other do's, again, with our landlord hat on, right, proprietary hat, you want to ensure that everyone in your organization understands that this order does not grant a right of free location, co-locations on government property. We've already seen that happen in one community where the local government was the landlord. They had the right of approval. One of the large national carriers sent a note saying that we're entitled to make these change-outs under this new FCC rule, and it was like, no, stop right there. So we know that people will try to take advantage of the market, in the market of these new rules. Make sure that you don't grant rights in your leases and licenses that give away those rights, right? So again, make sure that you make sure that your licenses and your leases require landlord approval. Whether or not you want a fee share, that's up to you. But there's no reason why you should ever not have approval of not only the additional party going up there, but how they're going to go up there and how it's going to look. And I hope that you'll police your leases to make sure that that's the case. And as I said, make sure that the industry doesn't try to misread these to install generators or to switch out equipment at your sites, because in fact the switching out of the generators and the equipment on your site may be something that qualifies under 6409 from the regulatory standpoint, but it certainly doesn't qualify under your proprietary rights if you have preserved those rights. Other thoughts on your process. I think that you should require the applicant to choose under what statutory term it's seeking approval. Are they asking for it under 332C7 or 6409A? None of this stuff of, well, we'll take whatever. Make them choose right up front. Make them choose right up front. And if it's not under 6409 and if they don't qualify, I would argue that you make them start the process all over again at day one for a 332C7, because there are things that I can ask for under 332C7 that I can't ask for under 6409A. And so, again, I would make somebody doing it right up front, and in so doing, they're establishing their own timeline. You're now seeing this last line for, oh gosh, sorry about that, folks. You're seeing this for the fourth time, and I apologize, but if there's one message that I can get through today, it is that you need to understand that as of April the 8th, there will be 3 federal shot clocks, and that the federal shot clock does not extend shorter state timeframes. And so if you're in a state that has a co-location requirement for 332C7 of 60 days, just because the 90 days was established by the FCC doesn't give you those extra 30 days. And if your state decides tomorrow, and we know that the wireless folks are still at it at the state level, if they decided tomorrow to pass a law that said that 6409A type co-locations, that is things that do not substantially change the wireless tower or base station, have to be resolved in 40 days, then that's what you get, 40 days. The federal folks establish sort of the maximum time that we have to work. If our state chooses to provide less time for us to complete our work, that's what it is. Also, you're limited to what you say on the first document as being missing. There's no opportunity to add discoveries. So things that you might want to do in changing your applications. Now, each one of these is listed in the FCC order, so none of these requirements, none of these questions could be challenged as being ineligible or some sort of a delaying factor. So these are the things that the Commission found were reasonably related to determining whether or not the eligible facilities request meets the requirements of 6409. You can ask them, do they meet the size change, and that includes the cumulative limit. You can ask if they meet any existing stealth obligations. You can ask them to document that they meet all building code obligations. They meet all safety code obligations. There's an additional thing in here that talks about non-discretionary codes and cites the structural code. You can make sure that they do that. You can make sure that they document that they comply with any condition of approval of construction or modification that is imposed on applicable wireless tower or base stations, i.e., does it comply with your fencing requirements? Does it comply with your access rules to the site? What about drainage and other conditions of approval that were placed on the underlying structure? Again, I think what this also says to you is that if you're not thinking about all these types of requirements when you're putting up a new site, then you better be, because you can't do it later down the road if you haven't done it for when it begins with. Some other lessons from 6409 that you might want to bring into your planning process. Fees are not addressed in the order. So, you know, folks don't get a fast track. They don't get a reduced rate. You can charge whatever you want to charge so long as you comply with your state law. And some states have got rules that limit you to the recovery of cost or time, etc. That's another reason why you need to make sure that at the local level you don't have an automatic conversion of a 6409A application that's denied to a 332C7 application, because you know, additional time and effort and manpower is going to be dedicated to the 332C7 application, so you ought to be compensated for that. So you want to be able to you know, apply another fee. It's not clear that you can demand documentation that the site complies with any relevant federal requirement, including any applicable commission, FAA, NEPA, or Section 106 requirements. I know that that's not very helpful. Some folks have said that maybe you conditionally approve upon the documentation that they reach all of those things. I don't know what to tell you on that, I'll be honest. Also, it's not clear what the status is of local historic preservation limitations. And if somebody's on from San Antonio with the Alamo, or Boston with its you know, historic walk, I've tried to get answers to those questions from the commission, and I don't have them, or at least nothing sufficient enough to tell you that you could rely upon it to move forward. Now the don'ts. Now the don'ts. Don't impose a moratorium. The commission is specific that they will not toll either, so you're just kidding yourself, or you're inviting litigation down the road. Now, you know, I mean, again, in the news is Spokane. You know, the question there is, do they actually even have any applications? I mean, if you have a moratorium and there are no applications, then it really doesn't much matter. And again, I don't know what's happening, the fact pattern, but the commission is absolutely crystal clear that moratoria will not serve to toll the 6409 or the 332C7 applications. So please understand that, and make sure that your local electeds understand that. Otherwise, you're just inviting litigation, I think. Don't approve anything without understanding how a facility may expand. The smallest facility may grow to an additional 10 feet up and 6 feet out. And again, I think from a planning commission standpoint, I mean, this is really your obligation. And I think as you seek to keep faith with the community and telling them how things may grow, if it's in the rights of way, it can get 10 feet taller and 6 feet wider, and how does that work? Same thing, you know, if you're looking at a tower that's right now underneath the tree line, or the applicant is telling you and telling the local community, hey, you know, this is good. You're not going to see this thing because we're below the canopy. Well, not really. That's not a promise that you can make long term, because if the 10% growth takes it over the canopy, then it's not there anymore. Please don't demand documentation for the business need for the proposed modification, or require that a business case for expansion be made. They don't have to do that. They don't have to do that, and you're just inviting litigation if you do. You're allowed to see whether or not it meets the substantial change test, and that's it. That's it. Okay. So now, I like to call this sort of the decision tree process. So you've done your do's and your don'ts, and so the question is, what is it that you're telling the city attorney that you need help with? What is it that you're telling the city council that they need to do? How do you move forward? Again, I don't think that there's any obligation that you change your laws, because almost all of your laws, I mean, have an out in them, a safety clause that says that if any of these rules are found to be inconsistent with federal law or any laws, you know, they're hereby repealed. So, you know, anything that's inconsistent today is sort of repealed as a matter of right. And now, again, you want to check that, you want to make sure of that, but I think that is the case in almost every one of your practice areas. I'm sorry, in every one of your local communities. So maybe you only want to change your practices. So maybe if that's all you want to do, I might suggest that you still prepare maybe an acknowledgement ordinance, right? You might want to say that the community, fill in your blank, Seattle City, New Jersey is aware of the new 6409A standards as established by the FCC in the order, and you might want to then have that staff is directed to act in compliance with the timeframes and limitations outlined in the report and order. You might go further and you might empower, an individual to review applications. I mean, nothing requires that the process be ministerial or non-discretionary, but sometimes if I'm a planner or I'm a city employee, I'd like to know that the city council or the town council or the county council agrees and acknowledges that I'm going to be making these presentations and getting these things done within 60 days. I don't want to be sort of left out there, unprotected when the co-location goes up, and it goes up quickly, and people in the community are angry because they didn't get a chance to participate, or they don't like the way it looks, and all of a sudden you're in front of the council and you're being berated, et cetera. So you might want to do this to make sure that you're protected. You might want to allow staff to require applicants to comply with extensive notice requirements and other procedural hurdles. You might want to have something in there that says, should any part of the FCC's order be struck down by a court of competent jurisdiction, the staff is directed to amend the community's practices accordingly. So again, this is sort of a simple way that you might want to look at it and move forward. And really here, all you're doing is you're saying we're aware of it, and we can act accordingly. And it's really, the planners, the building code folks are really going to run the show. But suppose you want to go a little further, and rather than sort of automatically rely upon things being repealed, you want to actually go in and change them. So the question here is, what if my community has a wireless ordinance that's inconsistent with the new FCC rule? Again, you can employ an acknowledgement ordinance in addition to directing the staff to act in conformance with the new FCC's order. You might make clear that any portion of the community's wireless ordinance, and you could cite to it or other codes or forms that are inconsistent with the FCC's rules, are repealed. You could repeat the reversion language should any part of the order be overturned. And then I have sort of one other addition here and in the next one, and that is, the community or the local electeds might even want to direct staff to come back with a proposal, 90 days hence or whatever the case may be, and conduct a workshop on where things need to change. And if your community is like every other community, something like that might be a wonderful opportunity for the planners to come in and just educate the law, the lawmakers on what are the conditions, what are the circumstances and the requirements that you typically impose, and get their buy-off yet once again. I just don't think it hurts. And then what if you actually want to amend your code to include the new language? Well, here's where it's a little bit different. At this point, I really think that you want to engage your counsel, whether it's your outside counsel or it's your city attorney. The national organizations, that is the National Association of Telecommunications Officers and Advisors, the National League of Cities and National Association of Counties, just developed a model agreement or a model ordinance with the industry. I've got some problems with it. I would note that the Conference of Mayors did not sign on. I've got some problems with it. I think it's a little conservative, but you might want to look at that as a step. I think the real issue with a national model is that each of your communities is at a different level of sophistication, and so if you just drop the model ordinance in there and you don't go in and you check your building code or your wireless code or your L&I or your your property code, I mean, there may be things that are inconsistent and you may not get it all done. So again, I think these things are best done locally, and I think that you need to do that. Make sure not to incorporate, and this is my one caveat, make sure that you don't incorporate into local law obligations that might not be in place in the federal law or that are subject to the appeal. So for instance, my recommendation would be that I don't think I would write deemed granted in my ordinance. I think that I would simply say, communities aware that failure to act within the time period set out in federal rules, could result in certain relief being obtained by, the applicant. I wouldn't write in there if we fail to act within 60 days, it's deemed granted. And the reason I wouldn't do that is because if we're successful in having the deemed granted law overturned and you don't go back and change your law, then the deemed granted is a local standard that's still enforceable. And so I wouldn't do that. I think the other thing is that it's important to understand that the 30-day incompleteness note, the 10-day incompleteness note, and the deemed granted are all subject to OMB approval, and that's going to be months off, I believe. I mean, it hasn't even been put out in the Federal Record or Federal Register yet for comment. And I just told you that that there are a number of sections that are going to be subject to appeal. That is deemed granted in at a minimum the 10/6 growth within the rights-of-way. So be very careful. Please don't impose upon yourself at the local level a rule or regulation that doesn't exist at the national level. Spend the last couple of minutes with some additional strategies, and I've hinted about these all along, and I really, the price for me doing this is that all of you are now required to share with me your ideas on additional strategies that you might have been thinking about as a way to limit the scope of 6409 at the local level. So these are the minimum steps, right? So we already talked about, the consider enacting an ordinance that prefers government property for cell locations. And again, why do you want to do that? Because as a landlord, you have greater rights to govern the look and the operations of the site than you do as a regulator. And why not do that? And the additional revenue just doesn't hurt, right? You might want to consider your existing height limits, your setbacks, and your separation distances in your city or your county or your town code to accommodate what could be a 10% growth in towers. Again, you're not able to do this sort of retroactively, but you can do this moving forward, and you can start to try to reestablish some sort of control over the look and the management of your community by reducing or making the standards a little bit stricter. Okay, you might want to avoid permitting by grant. Now, what do I mean by that? Sometimes you can do a license agreement that doesn't require regulatory approval, but again is being done as a matter of the real estate owners or as of a right, right? And because if you do that, remember we spent that time early on talking about what's a base station, and a base station is that light pole. The base station is that whether it's a traffic light or a street light or it's one of these historic sconces. I mean, that only becomes a base station that's eligible for 6409 growth if there is a permitted wireless device on there. If there's a device on there that you permit because of your ownership rights, then it doesn't get to grow. And so that may work a little bit better, and it gets to grow. So something that you might want to think about. It also says that there are devices out there today that you're not permitting, and maybe you should continue not to permit them. Now, let me give you an example. Most local governments don't require the Starbucks or the Caribou Coffee or whoever it happens to be that has a little patio outside of their building. Most folks aren't requiring you to permit the Wi-Fi device that may be sitting over top of the front door so that people can use it out on the patio. And maybe that's a pretty good idea not to do that, right? Because again, if it's not permitted, then it can't grow as a matter of right. Because going back to the definition of the base station, because the base station, you know, a device only becomes a base station if there is a permitted wireless device on it. And so if it's not permitted but simply exists, you know, you avoid sort of that growth pattern. You might want to expand your existing requirements for stealth deployments because, again, unless there's a stealth obligation present at inception, you're not going to be able to go back and impose it when a 6409 co-location request comes in. So an example, you might want to authorize DAS in small cells of every size, but limit possible future growth by requiring stealth or the restriction of placement on utility poles. Again, so if I can't get at it, I try to anticipate what the growth might be. I try to anticipate what the problem might be, and I try to address it with stealth requirements because, again, stealth requirements are enforceable even in a 6409A co-location request scenario. So, again, just things that you might want to think about. Some argue that the other thing that you might want to do is you might want to have stricter standards for your initial authorizations. You know, what does that mean? You know, again, you might want to require significant proofs of the need for the facilities. Some people are talking about allowing permits to expire and not renewing them unless the federal law absolutely requires it. You might want to require all facilities to have concealment elements. Again, it's trying to anticipate upfront what you're not going to be able to do. Again, this is a broken record. Favor your proprietary requirements. Again, try to move things onto your property as opposed to so that you can manage as the landlord rather than trying to regulate as you know, with your regulatory hat. And so let me see if I can summarize, and I think I'm over by a couple minutes, but we started a little bit late. I think, you know, and you've now heard this now the 6th time, understand that there are now 3 federal shot clocks for siting wireless devices, and that all 3 apply to DAS and small cell applications. Examine whether your laws or your forms are consistent with the new order's timeframes, and if there's not, make a determination, do you want to change your laws to conform, or do you want to merely change your practices? And with that, let me stop and turn it back to Christine, who I imagine is going to manage our questions. And I thank you for your attention. And there's my ugly mug and my contact information if you want to talk about any of the appeals or any of the questions you might have today. But so with that, I'll stop and I'll remind you all of my fee for this. And my fee for this is that you share with me your ideas on how folks might be able to affirmatively, proactively limit the impact of 6409 up front. Christine?
Great, thank you. Can you hear me okay?
I hear you perfect.
Great, okay. We have a lot of questions, so let's just kind of dive in. Okay, first question. Can you legally establish...
Christine, can I see these questions somewhere, or are they on my
No,
screen?
it's going to be a surprise for you.
Double secret probation, I got you.
Okay. Can you legally establish submittal dates and start the shot clock based on that date? For example, could every Monday be a submittal date regardless of when application is received and the shot clock measured from that Monday?
The order doesn't speak to that specifically. Again, you know, remember the admonition from the beginning, right? I'm going to do my best, but this you should not rely upon anything that I say from a legal standpoint. The order doesn't speak to it. You know, sort of the best you're going to do is save 6 days. I don't know that 6 days is worth the jeopardy. I guess that's my answer, right? I mean, I'm not saying you can't do it, but I'm saying that I think there's enough uncertainty that I wouldn't want to base my timeline on that, and I'd hate to be in a position where I relied upon that, you erroneously or unwarrantedly and wound up losing my ability to tell somebody that their application was not complete or have a deemed granted found against me. So I guess I don't think I would do that.
Okay. Next.
Now, if the office was closed and you couldn't apply, I don't know.
Okay, and I see a question in here or something like that. Attendees are automatically muted for our webcasts. It looks like there was a question about anyone not being able to speak. So if you have a question, your only option is to type it in, just so you know. Okay, next question. Could you just briefly, one more time, explain the difference between the 6409A and 332C7?
Sure. Couple differences, right? First of all, 6409A applies to any wireless service, whereas 332 really only applies to what we think of as cellular service. So that's one major difference. Second, so that's the scope of it. 6409A has a much larger application field. There's the difference with respect to the time. You've got 60 days in which to make a decision on 6409A. You've got 90 days to make it on 332C7. At 6409A, the only question that is before you is whether or not the proposed change at the cell site or at the wireless site, the only question before you is whether or not that change is a substantial change or not. That's it. That's the only question you're looking at. If it is a substantial change, then they're not entitled to the fast track approval. If it is, so if it's a substantial change, they're not entitled. If it is not a substantial title change, then they are entitled. So that's it. That's your decision process, right? Under 332C7, you have all the traditional things that you get to look at. So, but you got to do it in 90 days. So I think that that's about the best sort of short answer I can give as to the distinctions.
Okay. Thank you.
And Christine, you're not just a moderator, you're a full-time planner. If these answers don't make sense to you, please let me know, because it means they're not making sense to the audience.
Will do. But you're the expert on this, that's for sure. Okay. What would stop owners of non-permitted facilities to simply replace them with larger ones? As non-permitted, they escape any form of regulation.
I'm not exactly sure that I understand the question, but let me see if I can answer. When I'm suggesting non-permitted or permit by right, I'm talking about doing that most of the time in an environment in which I happen to be the property owner, and as the property owner, I get to manage with my real estate owner hat on, not my regulatory hat. So that's point number one. The second case that I was talking about, like not requiring permits for, Wi-Fi's outside of the coffee shop, there, I mean, I have the ability to come back in and enforce at a later date if the thing grows, right? I mean, I'm not granting that as a right. I'm just talking about sort of prosecutorial discretion here by the planners, right? I mean, that might not be something that you seek to embrace. So I hope that answers your question, but if it doesn't, type back in and tell me that I've missed your question.
Okay. I'll watch for that. Next question. What is the going rate per month for a cell site on government property? Any way to find that out other than asking neighbors?
You nailed it. You nailed it. That is the absolute best way to do it. And quite honestly, I don't understand why the American Planning Association or the American Public Works Association or IMLA doesn't, on a regular basis, conduct a survey where folks could, provide that type of information. The real estate world is a world that probably examines market comps, that is comparable market locations, better than any other industry. And when you think about cell sites, it's just a subset of real estate. And yet it's the only set of real estate in which one side, that is the tenant, has all the information, and the landlord typically does a catch as catch can. Now, I've got an idea on what rates are just because I'm lucky enough to work in a firm that represents, 60-some cities and at least that many special districts in California where, we do a lot of their cell tower work and license work. But yeah, no, I would think that the American Planning Association could render its members a significant service by, creating that sort of survey on a regular basis. And so, no, I didn't answer your question as to the value because I don't know where you are. But I would say this, that whatever you get, if you're not getting a co-location or a fee share, then you're under marketplace. If you're not getting at least a 3.5% annual escalator, then you're under market. If you're not requiring some sort of reimbursement for your legal and your legal fees or your consultant fees up front, you're probably under market.
Okay. Next question. I'm kind of molding a few questions together, so I have to work it out.
No, you're trying to make it hard.
I know.
You're trying to make it hard.
I'm just trying to group like questions because there's so many. I want to make sure we cover these topics.
Great.
Okay, so for the purpose of this ordinance, what is the definition of public right-of-ways? Is that any public land such as schools or parks? And are there any federal environmental requirements that fall into place as a public right-of-way that might be part of a wetland or some kind of waterway, something like that?
Yeah. So you guys are doing exactly what I worry that you're doing, and that is you're looking to some sort of a federal standard that you want the applicant to document that they've met, so that you can deny or delay, and all that's going to do is get you in trouble. My suggestion is that you stick to your local and your state laws, and you can note that the approval is conditioned upon them, obtaining those other approvals, but I would not get yourself jammed up on that. With respect to what a definition of rights of way, I'd have to go back and look. But most of those are most of that is based upon state law, what constitutes a rights of way, but it would not include a public park. So I mean, a public park would be a public land; it would not be a public right of way.
Okay. Okay, it's sort of related to this. What about a proposal that requires an EIS, an environmental impact statement? How does a federal shot clock affect the state environmental review timeline?
Well, again, an environmental impact statement why would the proposal require an EIS? If it's an existing structure in which the modification is being made that's not substantial, why would an EIS even be required? And I don't know the answer to that. I don't know. I'm not sure that I know the answer to that, but what I am telling you is that that's not your concern. Under the FCC rules, that's not your concern. Your concern is whether or not, look, I know I sound like a jerk, and I apologize for that, but but when I answered the question of what's the difference between a 6409A and a 332C7, what I said to you is that you have a single question before you in a 6409A application. Single question. Is the change being requested a substantial change or not? That is the only question, right? That's it. And you can look to your local codes, and you can look to the height and the width requirements in the federal thing, but with respect to historic preservation and federal, et cetera, I fear that if you look to try to impose those or enforce those, you're going to invite litigation. And again, I thank you for asking all those questions, because as we sort of prepare our brief for appeal, I mean, these types of questions are helpful. But again, I wouldn't be using those as the reason for denial. I might cite to those as the reason for a conditional approval.
The question, the person that asked the question just came back in and is not referring specifically to a modification of a pole, but for a new proposal, for a new tower site.
Again, no, okay, 6409 has nothing to do with that, right? 332C7 deals with new sites. You got 150 days, and if there's an EIS that has to come in from the feds for that to go up, then you know, likely the parties will provide for an extension of time. I mean, I think we deal with these all the time. For instance, if you've got an airport in your area, right, getting clearance from the FAA that that's not in a flight line or that the height is okay is something that happens all the time. So again, most people understand those, and thank you. Right, I appreciate the question now. And again, the differences between 6409 and 332C7 is that 332C7, you get to ask all the questions that you've always required and all the documentation that you've always required as to whether it's needed, and is that the location, and you know, are there better locations, is there a business case? You can ask all those things. That has not been taken away. You got to do it within a certain amount of time, right? We still have the shot clocks. But on 6409A, to keep yourself safe, you've got but a single question before you, and that is the change substantial? If it is, it's not entitled to the fast track. If it isn't substantial change, then it is entitled to the fast track.
Okay, so with that, is my definition of substantial different from your definition of substantial?
Why did I just do this whole presentation? Well, again, I'm sorry, were you listening? I mean, this is what. Let me see if I can't get back and find it. These are the things that you can ask, right? These are the things that you can that are reasonably related to determining whether the eligible facilities request meets the requirements of 6409A. Does it meet the size? Does it meet stealth? Does it meet building code? Does it meet safety codes? Does it meet non-discretionary? Does it comply with pre-existing construction or operational obligations? That's it. So I don't know what your definition is of substantial, and you don't need to know what mine is. What we both need to know is what's the FCC's, and you know, and the FCC tells us what it is with respect to size, height, width. It tells us what it and that we're able to continue to, you know, require all these other things. And if any of those are not present, then it is a substantial change, and it's not entitled to a fast track.
Okay, next question. What is a stealth obligation?
I use stealth as sort of the catch-all for any kind of a screening obligation that you might have. Like, for instance, some communities require a rooftop deployment to be certain number of feet back from the edge of it so that it's not visible from the street level, or so that you don't lose sort of the historic sight lines, that type of thing. Other places a stealth requirement might be, we have an example of it, right? Let's go back up here. And I hope I'm not making people dizzy, but all right, so here's a stealth requirement, right? So each one of these little knobs here, right, each one of those is an antenna, right? And it's built into sort of an Adobe setup. This, you know, continues to try to do stealth. That is, makes it less visible. Give me another example, so, right? I mean, that's a stealth deployment, right? They created this cupola, right? I mean, right? This is not a stealth deployment. You can tell exactly what that is, right? But here, I mean, that's not absolutely evident, right? Here's other examples, right? This is not a stealth deployment. This is. So it's the idea of camouflaging, the idea of doing your best to require that the tower or the base station be incorporated into the surrounding areas such that it's not so evident. I mean, there are town clock towers that have been deployed around the country that are stealth. You know, folks have moved into steeples or have created steeples again, it's the idea that you can incorporate the wireless devices in such a way that it's not visible. It might be that there's screening or there is help me out, Christine, shrubbery. What would you call it?
Landscaping. Yeah.
Perfect. Right. Landscaping obligations would be part of stealth. So that's what stealth is. It's any kind of a screening device.
Okay, so can a locality require that small sites be placed within the right-of-way and only on existing public infrastructure, such as a light pole?
Again, we're talking about a siting question here, not a 6409 question. You know what? I'm not prepared to answer that question. I don't think that there's anything that prohibits a locality from providing that as a fast track for obtaining deployment. The difficulty is that that there are not just wireless 332/6409 type rules involved, but there are rules. Section 253C provides protections for telecommunications providers, and one might argue that if you're a 253 provider, that you're entitled to the same rights of existing providers that are already there. And so I'm just a little bit scared to make a blanket statement, Christine. And if I'm a chicken, then so be it.
That's fine. Okay. Is the term, and we're almost finished here. I'll wrap it up here shortly. Is the term base station exclusive to structural enclosures or antenna mounts? Or is the term base station also appropriate when referring to the equipment area immediately around the tower?
Well, here's the definition. The equipment and non-tower supporting structure at a fixed location that enable commission licensed or authorized wireless communications between users' equipment and the communications network. So if the stuff around the tower is necessary for the communication service, then yes, it's part of the base station. And a specific example of that might be, for instance, a backup generator. I like when they ask questions that I can go to the page.
Let me see if I can find some more of those for you. Okay, what does a DAS and OMB approval mean?
OMB stands for the Office of Management and Budget. There is a law called the Paperwork Reduction Act that requires that any agency that's going to create a paperwork obligation on parties have that paperwork obligation approved by OMB before it can be enforced by that agency. Since the 30-day letter, the 10-day letter, and the deemed granted letter would create such obligations. They're in the rule, but they're not enforceable until OMB has approved. DAS stands for Distributed Antenna Systems. That's the idea that rather than have one big tower, we'll do 10 little towers. Little towers being something as small as maybe a foot-tall antenna around the locations. For instance, a DAS system is probably what you find in most airports today, what you find in most large convention centers. It's the idea that you create smaller cells, and so that increases the capacity of the spectrum within that area. It reduces the amount of power that needs to be exerted at each one of the cell sites or the antenna sites, and so it increases efficiencies and reduces RF threat. So yeah.
Can a municipality require propagation studies from a collocation application that falls under 332C7?
Anything that you can do today, you can do. You can still do. I don't know why. I don't know why I'd want a propagation study on a collocation if I have an existing site already there, and under 332C7, I can require stealth and all those safeguards that I've had before. I mean, I can't require a propagation study under 6409, but I don't know why I want to do it under 332C7. I want to do it for collocations. I mean, I want to do that for new sites, right? To determine that that's the right. But once the tower's up, I don't understand why you would want that study. I don't think there's anything that denies you. Nothing in these rules denies you asking that. But I don't understand the logic behind wanting it. I mean, typically propagation studies are used to tell people that they ought to go co-locate at an existing site as opposed to putting up a new site. So I apologize. Maybe there's a sophistication and a nuance to the question that's just over my head, but it seems a little bit in reverse.
Okay. I think we have time. We'll do one more here. Does 6409 apply only to a first collocation or to multiple subsequent collocations?
It's a wonderful question.
Oh, then that's a good one to end on.
It's a wonderful question, and it gets us back to, we talked about cumulative, right? So if I have a 100-foot tower and I want to add an array of antenna at 40 feet, so I'm not taking it up at all, I'm just adding them on at 40 feet, and I meet all the standards, right? So I've not increased height, my width is less than is permitted, I'm entitled to 6409A, boom, it's done. And then if I want to come back 5 years later and I want to put something at 60 feet, and again, I haven't changed anything and it's in compliance, then I'm eligible again. And if I want to come back a third time and now I want to go up, you know, a height to do an additional array, I want to go up 20 feet, I'm entitled because, again, I haven't, you know, I haven't expanded outside of that sort of imaginary envelope that's you would draw around the tower to say where changes could be, right? So I can envision a tower in which there are multiple 6409A applications that are all eligible. I can envision a tower in which none would be eligible, right? Because, for instance, let's go back to this picture of the flagpole, right? Let's go back to the picture of the flagpole, and suppose that flagpole today is sustaining, 4 different carriers in it, and you wanted to put a 5th one in there, but it was such that you couldn't do it without losing the stealth, the concealment obligations. Well, then you couldn't do it. You couldn't do it. The tower here in the middle, this tower here, I mean, this is pretty loaded, right? And so maybe the only way to do something else here would be to go up. And again, if I can go up and stay within, the height limitation, the 10% or the 20 feet, then I'm good. So yeah, so I think the answer to the question is that yes, you can have multiples, but the point that we tried to make with respect to the cumulative is that you cannot continue to grow a tower. It can't sort of continue to bud and move up and up and up.
Okay. It's about that time. So thank you. Gerard Letter was our speaker for today. And so thank you for joining us and for answering all these questions. We appreciate it.
My pleasure.
And to the Northern New England chapter for sponsoring today's webcast. Thank you. And the PDF of this presentation will be available at ohioplanning.org/planningwebcast. And it is recorded, so by Monday it will be up on our YouTube site. Again, I know. So then you'll be able to view it and hear your voice.
No, thank you.
Just search Planning Webcast if you want to hear them again. So that's it for today. Everyone, have a great weekend, and we'll see you next time. Well, we'll talk to you next time.
Bye, Christine.
Bye-bye.